Good evening, good evening, good evening. I'm Vince Scully, and this is Life Sherpa's Life After Hours. That time of the month when we shine a light into the dark recesses of personal finance. And tonight, we're talking about sorting your paperwork, or more specifically, the paperwork that looks after you when you can't or you're no longer here. So we call that looking after your legacy. But before we get into that, let's just bring this back to the Life Sherpa 8 Steps to Financial Freedom. We have 3 foundation steps: spend less than you earn, build an emergency stash and pay off your debts. That's steps 1 to 3. Those 3 protective steps, which are the things that help keep your goals on track, which is step 4, preparing for the unexpected. Step 5, getting your super basics right. Step 6, sort your paperwork. Step 7, the first of the growth steps, which is the stuff that makes all this sort of feel worthwhile, and that is buy and pay off your home. And step 8, invest your surplus. So tonight we're looking at step 6, which is sort your paperwork. And in many ways, this is the make your bed first thing in the morning of personal finance. Admiral McCraven wrote a book on that with that title. And the point of it was that if you get some things done early in the day, the rest feels like you're winning. So his view was that you should tidy up, make your bed, and then you can move on comfortably into the day. And sorting your paperwork is a bit like that. There's a few things to sorting your paperwork. There's the obvious stuff about that day-to-day paper that we potentially get drowned in: bank statements, pay slips, bills. And that's really about developing a system that helps you organize it. Automate as much as you can, go paperless where you can, keep an inventory of what you own and what you owe, and dump everything you don't need. Declutter your paperwork. But probably as importantly is organizing it so that whoever needs to take over if you can't doesn't just find a mess. So if you think about what would happen if your partner or parents or siblings had to take over your finances tomorrow, would they know where to find everything? Would they know where everything is? So help them untangle the puzzle and don't leave a mess for other people. That's the message of that. But tonight I want to focus on the other aspect of sorting your paperwork, and that is the sort of the legal paperwork that enables people to look after stuff if you can't, either because you're still alive and are unable, or you're overseas, or you've died and somebody has to sort out your estate. You've probably heard of some of these documents, and they go by different names in different states. So your will, obviously, you probably heard of an enduring power of attorney. What about an enduring guardian, or an advanced healthcare directive, memorandum wishes, or a binding death nomination for your super? We'll come back and see what they all mean, and they all do different things and are called different things in each state. So focusing on the stuff that needs to happen while you're alive when you're not available. And there are things like paying your bills, authorizing financial transactions. So, if you're not available, how is someone going to withdraw money from your emergency stash to pay your medical bills? How is somebody going to organize your living arrangements? If you need care, you need hospitalization, you need someone to look after you, how is someone going to arrange that? And deal with doctors and healthcare professionals who will need somebody to consent to treatment. And of course, to express the wishes of how you might want your life to end. Do you want to be kept alive a long time? Do you want to give someone instruction not to resuscitate? How do you want to be buried? Do you want to be cremated? All of those things, right up to the point of death, are dealt with in one way. And then after you die, that's where your will and these other documents cut in. So we're going to look at both of those tonight. That's the key message. So This usually raises lots of questions, so feel free to hop in the chat and drop in your questions. We'll deal with those as at the end. There'll be plenty of time. I'm only going to spend about 15 to 20 minutes talking about this because these sessions are all about you. So it's about your questions and getting answers. So think about this like office hours at your in your uni days. So moving on to the things that need to be dealt with while you're still alive. There is the obvious, which most people think about. Certainly, if you've ever been to a financial advisor, the thought of how do you deal with legal and financial matters when you can't? And that could be, taking money out of a bank account, could be cashing in a term deposit, could be making an investment, it could be selling your house. All of these things require a signature. And while you're not capable, you need to have somebody do that for you. And that's what we traditionally know of a power of attorney. That is, while you still have the power to make these decisions, you still have the mental capability, you still have the physical capability to make these decisions, you would have a power of attorney. And that might be useful if you're overseas or you're out of town and you need to get a contract signed. These are very common in companies. You might even have one for your dealing with the body corporate at your apartment building. But they cease to be of effect when you lose capacity. So that's why you need what's known as an enduring power of attorney. That is one that survives your loss of capacity. So that's the legal and financial piece. Personal matters deals with things like where you live, who cares for you, what you eat, how you dress. So these can be important if you're not able. Often this can be a big deal for older people where you get dementia, but it certainly happens in younger people too. So it's not just about old people. The third category is around medical matters. So if you are in hospital and someone needs to consent to an operation, then you're going to need someone who you give that power to. Usually that will be your spouse, if you have one, or your parents, if you're still living at home, perhaps. And this is about giving instructions or consenting to operations, usually, or medical treatment in general. And then finally, there's what we call medical preferences, and that's really the end of life piece where you want to give instructions that will be binding on medical practitioners. So the medical matters one is really your representative consenting to treatment. The medical preferences is largely about telling healthcare professionals what they can and can't do in terms of prolonging your life or particular treatments that you may or may not want to take. So these four types of activities are governed by a number of documents that are slightly different in each state. So we've got a little map here. There's a copy of this in the chat. So you can go into the chat, click on the downloads and save this for later. So the main documents here, if we start with New South Wales, where we happen to be tonight. So the enduring power of attorney is the legal and financial stuff. That's pretty traditional, pretty straightforward. New South Wales has then got a document called an enduring guardianship, which deals with your personal things like your living arrangements and also your medical arrangements. And then there's a thing called an advanced care directive, which deals with your end of life stuff. The ACT has simplified this a little bit. So if you live in Canberra, you've only got to deal with two documents. So the enduring power of attorney deals with financial and contracts, personal things, and medical. And then you've got a health direction form, which instructs health practitioners as to what they can and can't do. The Northern Territory, not many people live there, but it's got the simplest of all. There's just one document that deals with everything. South Australia has 2, Queensland has 2, and West Australia and Victoria each have 3. So in Victoria, it's an enduring power of attorney for personal and contractual, and then a medical decision maker for the consenting to stuff, and the advanced care directive for the end of life. You can download these, and it's a useful way of thinking about it. But these things are all governed by state law. So the state that you reside in, the state or territory where you reside, is the key determinant. Most of these have very strict rules about how they need to be signed. Most need to be witnessed. So your lawyer will help you get this right. So that's the while you were still alive stuff. And now we're going to move on and start looking into, well, what happens when you die? And there's some very arcane legal stuff that governs this. Some of this stuff is thousands of years old. A lot of it dates back to before the Crusades, and is steeped in legal stuff. So very important to get a lawyer to help you along with this thing. And this is just an outstanding or an outrageous statistic that 70% of the wealth will be lost in the transition to the next generation. And much of that is because that over half of Australian adults do not have a current or valid estate plan. And an estate plan in this context is more than a post office will. It's more than an online tool. It's very much a plan for how you want your stuff to be dealt with, and how you pass it tax effectively to the next generation or wherever you want it to go. So when we die, the core document is a will, which deals with the disposition of what we call estate assets. So that's assets that you control. So your bank account, your shares, your bonds, but not your super or assets that you hold jointly, nor does it include life insurance proceeds or trusts and companies that you might control. So the one that's effective that applies to just about everybody is your super. So your superannuation interest sits in a trust. Often that's a public trust. Sometimes it's a self-managed super fund. Sometimes it's a investor-directed platform. And the trustee of the super fund is charged with deciding where it can go or where it should go. You can guide that process. You can give the trustee an instruction called a superannuation death nomination, which says, I want my super to go to X. And X must be a dependent. So usually that's a spouse or a child under 18 or an adult child with a disability. It could be somebody that you have what's called a codependency relationship with. That might be, two single people living together who look after each other, or maybe you look after an aging aunt that you don't necessarily have to have a blood relationship with. And you can fill out this form, some very special rules about how it needs to be completed, signed and witnessed, and give it to the trustee of your super fund. And that can either be in the favour of one of these dependents I just described, or to your estate. And if you do it to your estate, you will then get dealt with in your will. There are lots of reasons why you might not want that to be the case, but you need a dependent if it's not going to go to your estate. Jointly held assets, another interesting one that people tend to forget about. Many couples own a home jointly, or is what's known as joint tenants. And in that case, the two interests are not actually separable. So when one of those joint tenants dies, the whole of the asset just passes to the other one without passing through a will. It just becomes the other person. Usually you need to change the name on the title, but that's a relatively trivial piece of paperwork. So it's not yours to give away to anyone else in your will. It just passes automatically to the other joint tenant. And that contrasts with what's known as tenants in common. So if you're buying property with your brother or a mate, usually you'll do that as tenants in common. And in that case, the different interests are separately dealt with, and your tenancy in common in that property would form part of your estate. Appreciate that's a little bit arcane, but that's why you need a lawyer to deal with this sort of stuff. Life insurance proceeds or investment bonds, again, they will usually have a beneficiary, and the insurance company will pay that directly to the beneficiary. Doesn't pass through your estate. If you're a beneficiary of a trust or the trustee of the trust, then your death will mean that a new trustee would be appointed in accordance with the rules of the trust deed. If the trustee of the trust is a company or a corporate trustee and you're the shareholder and director of that, then your shares in that company form part of your estate to be dealt with in your will. And the new owner of the company could appoint themselves be appointed as a director and potentially exercise the powers of the trustee company. That's starting to get pretty complex, and especially if you have partners in some of those companies, or you're running a business through a trust, all of that needs very specialist legal things. So taking those assets aside, you're then left with your estate assets, which get dealt with in your will. And that will can either give stuff directly to somebody, or where there are children involved, it's common to use what's called a testamentary trust. Testamentary really just means it arises because of a will. That's where the expression last will and testament comes from. And a testamentary trust holds the assets separately, and it gives a better tax outcome if there are children as beneficiaries. As you may know, children get penalty tax, so they don't get a tax-free allowance. If they earn more than $416 of taxable income, they pay 66% tax, whereas a testamentary trust would enable them to get the benefit of the tax-free allowance. So if there's any substantial assets, maybe $200,000, $300,000 or more, and you're going to a minor, so someone under 18, then a testamentary trust is probably something that you should consider seriously. The other reason you might use a testamentary trust is if you have a beneficiary who is needs to be protected. They might have an addiction. They might have a drug, alcohol, or gambling problem, and you might want to help preserve their cash for their good. Or they might be married to somebody or going through family issues, domestic violence perhaps, and so that's a good reason why you might want to conserve the assets separately. In overseas jurisdictions where there's an inheritance tax, there's a whole bunch of different considerations, and trusts are very common in those jurisdictions. We don't have a inheritance tax generally in Australia. Your super may very well be taxed if it's left to a non-dependent, and so there are some strategies you can use to minimize that tax. And it's certainly something you should be talking to your advisor or your Sherpa about if you have adult children or somebody else you'll want to leave the proceeds of your super to, then there are some strategies to minimize that tax. And then there's the dealing with what happens to your children. We obviously don't have slavery in Australia, so you can't force your child. It's not Harry Potter. You can't force your child upon somebody else. But you can certainly create a plan for what you'd like to happen and create a set of wishes to guide the executor or potentially a family court, depending on what's happening. And there are a whole bunch of things to think about here. I've written an article that sort of highlights some of the issues, which I'll link to in the chat. But you certainly need to think about who would you like to look after your child? How are you going to prepare financially for that? So is asking your best friend or your sister or brother to look after your child, are they going to need some financial help to do that? And there's where your life insurance or other will type items can help. And then finally, there's a letter of wishes, which is really guiding. Again, it's not binding, but it's guides the executor of your will. That's the person charged with executing your instructions in your will, and it can help with guiding that. It may also provide some rationale to explain why you made the decisions you made. That can often help to avoid people contesting wills. But all of this, you can see that there's a lot more to this than a $20 post office will. So to the extent that you have any assets, to the extent that you have children, you certainly should be thinking about all of these things. And this becomes even more critical where you have blended families or former spouses or issues around family dysfunction, for want of a better word. So much of the work to be done here is actually thinking about what you'd like to happen. And so for a couple, it's quite often common for the couple to leave everything to each other. But what about when both die together? If you were both to die together, quite often it's assumed that the older one died first, and quite often wills leave bequests, particularly in countries where there are inheritance taxes, where the bequest or the gift to the beneficiary is conditional on them outliving you by more than 45 days or a period, so that you don't pass through two estates quickly. So all of these things need to be thought about before you get in front of the lawyer who's going to help you draft this. What you don't want to be doing is thinking about which of your third cousins is going to get your mother's wedding ring in front of a lawyer billing you $400 an hour. These are things that you really want to get done in advance. And so the thought process is pretty critical. And I'll come back to how your Sherpa and Life Sherpa generally can help you work through those thought processes. There is some good thinking in the Guardian article about that specific topic, but it's very much an emotional decision as much as it is a financial decision. So there's some very important people, who get involved in this exercise. The most important one is your executor or trustee. And this is sort of a bit similar to your power of attorney. So you really need to be able to trust this person. You need to make sure that they are able and willing to take on the task. They can't be forced to do it. They can reject the appointment, but generally you want someone who has their wits about them and is capable of thinking these things through. So your executor is responsible for applying to the court, the Supreme Court in the state, for probate, which is really just an order from the court giving them the right to manage it. So that's really about saying, are you dead? Is this will valid? And is this person the person that's nominated in the will? And are they willing to act? And so their job then is to gather up all the assets, to make sure that bills are paid and stuff owing is collected. They're responsible for ensuring that all the assets are accounted for and the tax returns are all done. And importantly, dealing with any legal proceedings. Usually, they will be working with a solicitor or lawyer. The lawyer who drafts your will usually store it in their locked room or their fireproof safe, and that does a few things. That one, make sure that you know where to find it, so you don't need to share the will with people, but you can tell your various people who need to know where it's stored, and then they can go and talk to the lawyer. Lawyers are good at sharing their details of whose wills they have. So if you don't know where the will is, often the lawyers can use their network to work out which lawyer is holding the will. Part of the reason they offer that service is they then are in the box seat to get the work to help the executor deal with all the legal stuff. You're not obliged to use them, but it's often a good place to start, and it's one less decision to make at the time. But there's no obligation to use them. They'll need to pass the will over to another solicitor that you choose. But generally, your next of kin would go to the lawyer, get the will, and get the paperwork moving. This can take anywhere from months to years, depending on complexity. And the better it's documented, and the better the paperwork and the ability to find everything is organized, and hence the make your bed in the morning analogy, that making it easy for people to find all this stuff so that you're not spending legal or accounting time and therefore money to unpick all of the complexities in it, especially if there's any complex structures like trusts or companies. For ordinary people, it's really usually the house, bank account, investments, super fund, insurance policies, loans, and the executor is responsible for pulling that all together and executing the will. The next most important people are the beneficiaries. So they're the people who you nominate in your will to receive those assets. You can give specific gifts. So you can say to my nephew Steve, I leave my wine collection. Now the interesting thing about doing specific gifts is that if that asset doesn't exist at the time of your death, then the gift specific will just fail and they won't get anything. So if you're thinking about gifts to even stuff out among people, be very careful with doing specific gifts. Often it's easier to allocate a percentage. But certainly specific gifts can be very appropriate where there's a some sort of emotional or sentimental link. And then usually there will be a residuary beneficiary. That's someone who gets what's left after everyone has get it. Often that's a charity, but often it can be anyone you choose. So think wisely. Now, once you've done your will, you can, of course, change it. You can't just cross it out and scribble on top of it. There is a process that needs to be gone through, and usually it's best to have a lawyer work on that. Interestingly, a marriage or divorce can affect your will. So if you get married, it will invalidate a prior will unless that will is made in anticipation of a marriage. Divorce is or death of a spouse is also likely to deal with that. In New South Wales, the will itself will generally remain in force, but that any particular bequests to a ex-spouse will be void. That's not something I would rely on, so you should certainly revisit these documents and these arrangements from time to time. 5 years is sort of a good number, or whenever anything material changes. So you get married, you get divorced, you have a kid, some of your beneficiaries dies, you have a major change to your assets or the structure, you start a business, you close down a business, you get a business partner. All of these things are good reasons to revisit your whole estate planning arrangements. You may not have to change them, but you should certainly be revisiting them. I touched on testamentary trusts earlier, and this is a structure created by your will. It's a trust, so there'll be a trustee. Often the same person that was your executor will take on that role, but not necessarily. And they're usually for the benefit of children or what we call at-risk beneficiaries. It can certainly help with tax effectiveness, and usually they will have a provision that says when the child reaches a certain age, that trust can be what they call vested, so the assets transfer to through the child, and then the trust gets wound up. That may be longer in the case of where you're trying to deal with the needs of an adult child, or perhaps a child with a disability. There are other things called special disability trusts where you're dealing with disabled children, so that's something else to think about. But generally, that testamentary trust will be fairly common where you have minor children or one or more of your beneficiaries is at risk due to usually things like alcohol, drug, gambling addictions, or you don't want the assets to pass to a divorced spouse. The other place this can be really useful is in the case of blended families. So where parents remarry, so you may have so for example, my parents, my mother died when I was at university. My dad remarried. His new wife has 5 children of her own. So the arrangements, so if he predeceases her, so he dies, and she will obviously get a significant portion of the estate. But what is to stop her then changing her will and leaving it all to her kids? They're the sort of, I'm not suggesting that's happening in my case, but that's the sort of thing that sometimes a trust could deal with. So you could leave those assets into a trust and leave the surviving spouse with what's known as a life interest. So you could leave the family home, a life interest in the family home, so that she can live in it for the rest of her natural life, and then the residual value of the home then stays in the trust. I say her, not being presumptive or intending to be sexist anyway, but usually the wife outlives the husband. And that's because, firstly, women live longer, as a general rule. And secondly, blokes have this horrible habit of marrying younger women. So there are far more widows than widowers. So that's why we often talk about widows as the beneficiary. There's just way more of them. We'll be seeing fewer and fewer. And so there's an old joke that only an actuary marries an older woman, because that's actuarially the right answer to do. So obviously a female actuary would marry a younger man. And then that brings us on to the concept of guardians for your children. Again, this is a big emotional minefield that needs a lot of thought. That article in the chat deals with a lot of the questions you should think about. And so really it's a question of finding someone who has the right lifestyle and physical ability to look after your children long term. With people having children later in life, your parents may very well be, not in a physical position to do this. So be mindful of that. Of course, you can't force someone to be the guardian, so it's useful to talk to them and make sure they are willing to take it on. And then, you may have some wishes as to how your children are to be raised, what school they could go to, where they should live, whether they should live near their grandparents. All of those things are particularly important. And of course, then there's the dealing with the cost. So if you want to hand your three children under 10 over to your older sister to look after, do you need to provide her with some additional financial resources to do that? You might want her to move into your house because she lives in a unit, and is she going to still live in that house after the kids have left home? So lots of fairly complex, family sensitive issues. And so that article forms a bit of a useful checklist. This again can be important with divorced parents. So there would be a general presumption that the divorced spouse would effectively have first dibs on it. So if there's a reason why you don't want your ex-partner to look after your kids after you die, this is a pretty important piece of paperwork to look at. And so a lot of the problem with this sort of space is that there's a lot of stuff to think about. The legal mechanism of putting those wishes and plans into place is relatively tried and true legal technology. The challenge is gathering the information and putting it in a way that you minimize the amount of time the lawyers have to spend, because lawyers are one of the more expensive professionals that you will engage with. And so you don't want to be having these sort of discussions at $400 an hour in front of the lawyer. And the concept of, this might be one of the few places apart from buying a home that people deal with lawyers. Generally very professional people, very highly regulated, generally very ethical, and but they tend to charge by the hour. That's the model that they've been used to, and they'll, if you get billed in 6-minute increments, it can be interesting that the bill can be uncertain at the outset. So we've partnered with a technology partner called Yodel. So that's a platform that allows us to help you work out which of these documents you need, help you work your way through those thought processes and connect you and those documents with a pre-vetted professional. We have fixed price arrangements with all of these lawyers, and of course your Sherpa knows much of your financial ins and outs, so it can help make sure nothing gets missed, and certainly this can be aligned with your super and other planning and super insurance, for example. So this tool, it starts with a needs assessment, which will then give you a fixed price quote on the documents you need and connect you with a lawyer that operates in your state and can deal with all of the local filing. And this can generally be done wholly online. The execution bit at the end is the bit that takes a little bit of logistical organising, but it can be done. But this sort of uncertainty about the total cost is the thing that often puts people off getting started on this. So we find that this technology platform streamlines that and makes sure you start the process knowing precisely how much it's going to cost. So we're very pleased to add this to the Life Sherpa platform. We've traditionally worked with local lawyers across the country, and that can be, very difficult to ensure quality. It can be difficult to get upfront clarity of pricing. So we think the certainty of getting a fixed price quote upfront and knowing you're dealing with a trusted lawyer in the relevant jurisdiction. So it's about guiding your journey, it's streamlining the process, giving you a fixed price, and facilitating all of these thought processes to make sure that you've got it all done up front. That tells you the right documents you need, and then the legal process becomes fairly simple and straightforward. So talk to your Sherpa about that. And that sort of brings me to the end of my slightly longer than usual presentation. And so now it's over to you to deal with the questions.